That's what we call ourselves, if you like. It's the Office of the Scottish Charity Regulator, is the full mouthful, if you like. And the team that I work for, what we do is we assess applications for charitable status from bodies which would like to become charities. Not only that though, what we do is we deal with existing charities that are looking to make changes, whether it be to their name, to their constitution, to their purposes, or even to their legal form. So some of these changes you might have to come to us for if you're looking at taking on assets, depending on what sort of a charity you are. You may be wondering in the first instance what Oscar's interest is in asset transfers. I mean, we acknowledge that asset transfers can be a major opportunity for charities to expand their activities and to provide public benefit, which is what they're required to do. So what is Oscar's interest in this? We don't regulate local authorities, we also don't regulate asset transfers. Our interest though lies primarily in the activities of charities and the behaviour of charity trustees, and also the decisions which charity trustees make. Therefore, our interest lies in what are the basics of charity law, if you like, in particular charity trustee duties, and also the protection of charitable assets. Once an asset is taken on by a charity for its purposes, it must be used for these purposes. What are the charity trustee duties? These are laid out in the legislation for charities, and these are that charity trustees must act in the interests of the charity and put the interests of the charity before any other body. They must ensure that the charity operates in a manner which is consistent with its purposes. They must act with due care and diligence, and they must ensure that the charity complies with the Charity and Trustee Investment Scotland Act 2005 and any other relevant legislation. So in respect of asset transfers, the first of these duties is absolutely key. When trustees are looking at the terms of a deed, of a licence or a lease, they need to know if it's in the interests of the charity on the terms that are offered. So it's particularly important if there are any terms and conditions to the transfer that they decide whether or not carrying out the transfer and taking on the property is in the interests of the charity. Now, again, I was asked today to try and think 5 things that trustees should ask themselves. This kind of echoes what Diane has just said from details, although in a lot less detail. The first point here is taking on the asset on the terms offered in the best interests of the charity. In considering this, we would expect charity trustees to exercise normal business sense. What are the terms, if there are any terms, that is. They also need to think long term, to look at the whole picture. Are any terms too onerous? Are the terms compatible with charitable status? Have they done due diligence or taken appropriate advice? And again, what we've heard this morning, there is advice available. You know, organisations like DTAS will offer excellent advice. Also, there's third sector interfaces as well, which can advise you in things like this. They need to look at what are the benefits, what are the risks, and again, as we've just heard, we need to decide whether or not it's an asset or a liability, the property that's being offered. The second question that trustees must ask themselves is whether they can take on an asset at all. Does the charity's legal form allow it to own that type of property? If you're a charity and you are an unincorporated charity, you cannot own any property. So if that's the case, then you need to consider perhaps changing the legal form of your charity if you're going to own property. That's when you need to come to Oscr for consent to change legal form. You don't need our consent necessarily to take on an asset, but you would do if you want to change anything about your charity in order to do so. So if you're unincorporated, you might have a problem with this. However, if you're a SCIO, a company, or even a trust, then it could well be possible. The third question is whether taking on an asset is the best way of achieving the charity's purposes. Again, we'd ask the trustees to consider the alternatives because we realise that sometimes there's pressure in community-based charities to take on assets even where the purposes or the benefit is not absolutely clear. The fourth question is do the terms, and that's if there are terms, because there won't necessarily be terms, but do any terms permit third-party control over the charity? Another key issue for charity trustees is that they must be able to make decisions independently and which are clearly in the interests of the charity and not a third party. And the fifth thing they must ask themselves are whether any clawback requirements are acceptable. I don't know if any of you are familiar with the term clawback. I certainly wasn't until relatively recently, and when I was asked to do this presentation, I thought it might be best to sort of define what clawback was. Now, DTAS have this excellent booklet which I was given by my manager prior to doing this presentation, which is about asset transfer from policy to practice. It just came out in August 2013. And they say that clawback is a general term which refers to title conditions which can be used to safeguard the financial interests of the authority, and it can cover whether, when, how and to whom assets may be sold on, change of use and liquidation or winding up. So generally, clawback could be imposed through a charge or a legal condition. So you would have to consider whether or not there is any clawback conditions. And I will speak a little bit about that later on as well. The other key for charity trustees is that we are also interested in the protection of charitable assets. So if charity trustees do decide to take on a property or an asset, they must ensure that the asset or the property is used directly for their charitable purposes, and if they have to dispose of the asset at any point, if the charity has to wind up, then the disposal must be at market value, and any funds raised must be used solely for charitable purposes. So this leads on to just a little bit about clawback, if there are any clawback provisions attached to asset transfer. Whereas we appreciate the local authorities will occasionally sometimes add some clawback conditions where there's an asset transfer, we need to look at how this fits in with the necessity to lock in charitable assets if you are a charity. Our expectations are that charitable assets should be disposed of for charitable purposes and at market valuation, as I've just said. And we would have concerns if any charitable funds are expended to add value to an asset which would have to be returned to a non-charity, for example a council or any other non-charity under clawback conditions. And the final thing we'd like to say is, again, this is something that's mentioned in the DTAS booklet, is if you are a charity, you perhaps would like to question whether, if there are any clawback conditions, whether they're necessary. If you have an asset lock, you have to have an asset lock to be a charity, so therefore the asset lock in your constitution means that you can only use the asset for certain purposes, and these must be charitable purposes. So perhaps having an asset lock negates the need for any clawback provisions. And also there are protections for charitable assets provided by legislation, and provided in the fact that we are required to regulate all charities. And even if a charity that takes on an asset has to wind up, there is protection there as well, because charities that are winding up are required by the legislation to seek Oscr's consent to wind up, and we will only approve a wind up of a charity if the assets will continue, either be transferred to another charity or they will be sold and the money raised transferred to another charity. So even at wind up, charities must apply their assets for charitable purposes only. So if there are clawback provisions attached to a transfer, perhaps it's not necessary if you are a charity. Or if there's any other questions related to anything I've said today, I'll be happy to speak to you with the lunch hour and a half even. Thank you very much.